Hey y'all. Just made a last minute
Total
decision.
call, State of Wisconsin versus Jesse Kurczewski, 21 CF 885. May I have the appearances, please?
Good afternoon, Judge Randy Sitzberger,
Go live
Kevin
about
Nicolai,
this.
and J.J. Crawford for the state.
Donna Kukler is here, along with Pablo Galaviz and Ms. Kurczewski.
Although scheduled for sentencing today, late last week, the court received the first of two motions to withdraw from the defense team. Since that time, I've also had a response filed by the state, and then a response to that filed by Attorney
Welcome.
Kukler's office. This, of course, all followed on the 30th, the filing by the state of what it labeled as sentencing materials. Now, I've had an opportunity to review those sentencing materials today in preparation for that. I did ask my clerk, Teresa, to send an email to the parties indicating I wanted to review the original documents. I thought that was important given how those documents were described and what is at issue with the motions to withdraw. The state did that. Those were dropped off at my chambers initially, and I just want to make a record of this. All three of the state's attorneys and the two detectives were there, and I indicated I wouldn't talk to anyone without defense being present. I thought that would not be proper, and they indicated they understood. It's my understanding that there was an attempt to get a hold of both Attorney Galaviz and Attorney Kukler, and they were not available, and so they all left, and I indicated I'd let them know when I was done reviewing the documents so that they could go back to them. They were in a large paper bag, very apparent to me that it's being maintained as evidence. All of the individual pages were in plastic so that I could easily read through both sides, and was able to see what I believe, and I'll get confirmation of this, is the original envelope the state received the documents in. Anything?
That's the court's audio going in and out. It keeps going in and out.
First of all, Attorney Kukler, she answered at her office and said she was very busy and would not be able to make it, and that she was okay leaving the documents with Your Honor.
My bad.
I then tried to contact Attorney Galaviz and got his voicemail, but given the timeliness of it, we chose just to leave the documents with you and leave, as you stated.
All right. Attorney Kukler, since you were contacted, is there anything you would want to add to the record about that?
No, thank you.
All right. I think it's important that the court obviously address this motion before proceeding in any fashion with sentencing here today. I have some questions. I don't think, at least at this moment, I have an adequate factual record to really make a determination. Both Attorney Kukler's office and Attorney Galaviz filed a motion. There's some reference to ethical considerations, but none have been identified. I've done my homework. I've very meticulously gone through my Supreme Court rules. I think I've identified what might be potential issues or provisions of the Supreme Court rules. But I think it's important to note for everyone here, for Ms. Kurczewski, for the victim, for both parties, for the public, that motions that are brought before a court must comply with 80201. I don't think any of these motions do. Certainly no affidavits that have been filed. There's all conclusory statements that are made. I have denied many motions over the course of my career for failing to state a claim upon which relief can be granted when a litigant, whether pro se or by an attorney, doesn't present the request in a proper way. Now, it's pretty clear to me that the parties have responded to those filings, the state filing first, and then one in response, and given the nature of what's
Hi,
contained
Marie.
in the 37-page document, I have an idea, but I still need the defense attorneys to put forth a very particular basis. You could have filed an affidavit under seal if there was a concern. It should not be left to the court to guess or to assume what ethical prohibitions or ethical requirements you believe are at issue. The only thing, for example, Attorney Kukler, in your motion from your office is that it says professional considerations mandate. So what professional considerations mandate and what offer of proof can you provide to this court that, of course, is consistent with your ethical obligations? And when you address that, I need to also know to what extent you've discussed this with Ms. Kurczewski and what position, if any, she has regarding the request. So I'll start with you and then I'll turn to Attorney Galaviz.
I did have a conversation with Ms. Kurczewski by video conference or telephone conference, one or the other, and did explain it to her. And it's my understanding that Attorney Galaviz also discussed it, and she does not object to the withdrawal. The court, if you've seen the filings, you can see that there is an allegation within the, well, okay. Taking one step back, when I was provided with copies of those documents and observed the originals, I was informed by the state that they believed that these documents were not mailed, but were drafted by our client and somehow taken from the jail and dropped off at the person who the envelope is addressed to, dropped at her house by somebody, that they didn't drive there by the mail. And the suggestion within the documents is that, and the court, of course, could read that there's a request, and I'm not saying that these documents were drafted by Ms. Kurczewski, but the state alleges that
There's
they
an
were.
allegation.
They allege they were. And if so, Ms. Kurczewski has requested that this person who received this envelope that was dropped off at their home engage in what would be, I would say, illegal behavior. And the suggestion also is that, without naming the attorney, that her attorney supports or made the reference to the attorney supports this request by Ms. Kurczewski. And the attorney's not named. And there are only 2 attorneys that I know of on the case. And so,
What ethical provisions do you believe govern this conduct that you believe creates the conflict of interest?
well, I think it's an actual conflict because I've got the potential of being an actual witness in the matter that is been submitted, because I know what the facts are of certain things, and I'm an actual witness. Some of the documents that were submitted are handwritten documents from trial. They're on the back side of handwritten documents from trial. I'm an actual witness to many things that are discussed either in the trial with the handwritten notes and questions that were asked and so on. So I don't know how I can, when there's a possible allegation of professional misconduct, because that would certainly be professional misconduct if I somehow took an envelope from Ms. Kurczewski and knowingly delivered it to somebody, knowing that there was a request that that person commit a violation of the law. That would be illegal and a professional misconduct. So that's why I'm asking. I believe withdrawal is mandatory.
Now, I know in your motion, you cited the permissive provision of the rules of professional responsibility under 20:1.16 sub B, indicating that there would not be actual prejudice because Attorney Galaviz would remain on. And obviously, he's now filed a motion himself.
Right, and so at this point, I would cite to 20:1.16A. 1.
Are you aware of any filing or request that any Office of Lawyer Regulation look into any of the conduct that's described in the filing from the state, this 37-page filing?
I haven't been contacted by Office of Lawyer Regulation at this point in time.
Before I turn to Attorney Galaviz to get his take on some of this, I need to know from the state, you take great pains into, kind of painting this picture that you're no way, putting anything on any of these attorneys. I very clearly understand the state's position in terms of who you think wrote this, but this filing leaves a lot of questions for the court. I don't know how this person who turned this over, I don't know who it is. I know there's some names on it. I don't know if that's the actual individuals. I don't know if you're doing or if law enforcement is investigating this for any potential criminal violations, whether it's a conspiracy or anything like that. Or so I need a little bit more information from the state as to, how this information was turned over to authorities, and then how it came to the court.
Thank you, Your Honor, and I'll just give a full recitation of how the state came to be in possession of these documents. On Monday, November 27th, Detective Plennis emailed the state's 3 prosecutors here and notified us of this document that was dropped off at the Sheriff's Department approximately 3:00 a.m. on that Sunday, November 26th. It was dropped off by the person whose name was on the receiving part of the folder, who we've redacted. It is a woman who Detective Plennis has spoken to and has learned that that person served at least a brief amount of time in the Waukesha County Jail with Ms. Kurczewski. We believe that individual was present for at least one day, if not more than one day, of the trial here, who had visits at the jail with Ms. Kurczewski by video, not in-person contacts, and had phone contacts with Ms. Kurczewski through Ms. Kurczewski's jail phone calls. So that individual basically was a person who was trying to support Ms. Kurczewski insofar as she knew what it was to be a criminal defendant and know what it was to either not have a great deal of support or need support, and wanted to support Ms. Kurczewski while the trial was going on. She came home on the 25th of November, that Saturday, and was informed that this package had been dropped off with her. She has apparently a service through the mail where she was able to determine it was not delivered by the Postal Service, but somebody dropped it off in the envelope that Your Honor has seen. We took note, obviously, with that story that the envelope, though it does have 2 stamps on it, not counting the Waukesha County Jail stamp, there are no Postal Service markings over those stamps, as you would typically see if it went through the post office. She began reading through the documents, became very concerned, was not sure what to do with them. She contacted her attorney from her previous criminal cases, who advised her to turn them into the Sheriff's Department. Detective Plennis was notified, I believe, early on that Sunday morning that these had been received, and of course he notified us, as I mentioned before. There is an ongoing investigation into how these materials came from the jail and became delivered. We don't know. I think it's fair to say we don't believe the allegation in the, I'll call it, cover letter of these 37 pages that this was one of the attorney's ideas. I believe that's another red herring or untruth by Ms. Kurczewski, is our position. I can say with certainty that the attorneys themselves are not under investigation. There is an investigation into trying to figure out how these documents came from the jail without going through the US Post Office and came to be at the recipient's address. That's the extent of what we know at this time.
I mean, in looking at these documents, I
It's
noticed
so confusing.
there was no postmark. There's a stamp on an envelope that says this letter has been mailed from Waukesha County Jail with a date stamp. I don't know if you've been able to look at that to know if that's a legitimate way that they stamp it.
That, I'm sorry to cut you. That is a legitimate way the jail stamps envelopes. One thing the detectives are looking into is whether that came from within the jail. It is possible perhaps that somebody ordered a stamp to look like that. Detective Plennis did confirm that this envelope did not go through the Postal Service by talking to the postmaster, I believe. One other thing I'll point out is that envelope that it was received in was folded in half. There was a crease down the middle of it, while the paperwork inside of it was not creased, which would perhaps indicate that the envelope itself may have been included in a mailing, and that papers were put into it later. That's a possibility.
And just to, I guess, summarize, because these were some of the questions that I thought were important to my determination here today. The individual whose name that I saw unredacted in the original evidence, shall we say, that came over to me this morning, that has been identified as the actual person who received it with connections to Ms. Kurczewski and may have, in fact, attended the trial on one or more days.
Yes.
Don't know how the information got to her other than it was dropped off, and or how the information that the 37 pages left the jail, if it did at all.
Correct.
Is it the state's position that there is no conflict of interest based upon the contents of this letter?
Yes. My position is that if this were to create a mandatory withdrawal because of the conflict of interest, then why wouldn't anybody who doesn't like their attorney anymore simply accuse them of wrongdoing, right? They could easily come into court and say, my lawyer told me to lie on the stand, and so I get a new attorney now. It would be too simple. There's nothing, this is a baseless one-liner in 37 pages that says one of my attorneys came up with this idea. I'm paraphrasing, but there's no evidence behind that. And I do think it's important to note what I noted in my moving papers, that Ms. Kurczewski has absolutely denied being the one to write this. So as far as representing her at this point, it's my position that the defense team need only put that forth to the court that says, you shouldn't consider these because my client says she didn't write them. And the court can decide whether you consider them or not. Obviously, we have a very different position on what these are and who authored them, but that's Ms. Kurczewski's position. I think this would all be different if Ms. Kurczewski said, yeah, I wrote it, and one of my attorneys did tell me. That would absolutely be a conflict. But right now, there's no conflict presented because she's saying she didn't write them. And so it doesn't put the attorneys in a bind where they have to defend themselves. It doesn't put them in a position where they have to implicate her to save their ethical considerations. There's a very easy way that I've put forth already that they can zealously defend her by putting forth her own position on this pile of letters.
Attorney Galaviz, I'll turn to you next and ask you if you can provide some specificity as to what ethical rules do you believe are being implicated by this, and what is the actual conflict of interest based on this filing?
Judge, all I can tell you is I looked at the filing by the state, document 567, contacted the state bar ethics, ran it by them. They said I should withdraw the case. That's all I'm going to say.
When I look at SCR 20:1.16 that deals with declining or terminating representation, there is a section of that under a little bit kind of odd how it's numbered, but there's a small a at the beginning and then subs 1, 2, 3, and then under 3, there's in parentheses a B, which I believe is the provision for which both of you are seeking to withdraw, that states, except as stated in paragraph sub C, a lawyer may withdraw from representing a client if, 1, withdrawal can be accomplished without material adverse effect on the interest of the client. 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. 3, the client has used the lawyer's services to perpetuate a crime or fraud. 4, the client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. And if you look further down, there's an or. So it's not that all of these things need to be shown, it's an or. I mean, I don't have the benefit of knowing the basis for what you think is the conflict, other than there's this letter. It says not so nice things, but that's all. I have a denial, apparently, at least what the state is saying, that your client denies writing this. I mean, I could come up with a lot of scenarios where, obviously many people watch this trial. Anyone could take notes. I took time looking through all of this filing, and I think there might be some circumstantial evidence, if you will, that perhaps Jesse Kurczewski is the author. There's content, there are the trial notes, there's other things, but I don't know that anyone can definitively say that at this point in time. I don't even know if I should even consider this. I mean, that's one of the things. If I simply say, I'm striking this from the record, I will not consider it based upon the uncertainty and the ongoing investigation, how is there any conflict of interest?
May I speak?
No, not yet. You are still represented by counsel, and you
Judge,
need
That's
to
what I
talk
want
to
to
them
speak
first.
about.
No, hold on.
Judge, some of those papers in there have our handwritten notes on them. We know our own writing,
Well, I don't know that, do I?
but I'm telling you now.
But see, that's where an affidavit would have been really, really helpful. Could have been filed under seal, could have given me more information and avoid what I'm doing here in court on the record.
Understood. We recognize some of our own notes from trial.
All right, so you believe at least a part of that filing that has what appear to be trial notes were contemporaneously done during the trial, and you recognize your own handwriting on some of it.
Yes.
All right.
That's why I like this judge. She's very thorough. This is kind of complicated, and you can tell that she wants to be fair.
Look at also the confidentiality requirements that are applicable to both of you. There are some limited exceptions to what I would term as the confidentiality requirements between an attorney and a client. Some fall under a shall and some fall under a may. And even if I look under, and it's the SCR 20:1.6, says sub C, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. Sub 1 does not apply. There's not death or substantial bodily harm that you would be preventing. You wouldn't be preventing, mitigating, or rectifying substantial injury to another person. But here's where I think you could potentially be required, or at least asked to reveal, when it would be to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. Even if you believe there's some unwitting use of your services, the fact that part of these crimes for which your client now stands convicted involves theft from the estate and there's a pending probate case, I think one could argue that what's in this letter, if true, I think for purposes of the motion, I have to assume that it's true. I don't think I'm going to give you all the benefit. It's just for purposes of the withdrawal, Ms. Kurczewski, right? Your attorneys have asked to withdraw. I have to base it on some facts. And hold on.
I haven't had representation in the last week though, and I need to be able to
Ms.
speak to that.
Kurczewski, now is not the time. You will be given an opportunity, but I need to have facts upon which this decision of mine, which is a very important decision, be made. Counsel and defendants oftentimes have a disagreement on strategy. Relationships fall apart. That does not always mean that attorneys are allowed to withdraw, because as Attorney Sitzberger has pointed out, it would be so simple and it'd lead to absurd results if every time a defendant raised an allegation, whether it be an ethics complaint or criminal activity, if that were enough, we'd never have criminal defense attorneys, right? So there has to be something more. I'm concerned in this case because of the fact there's not a postmark on this envelope. And I'm concerned that there is an ongoing investigation as to whether it came from the jail, whether it came from you or someone else. There's other things it could be. Like I said, there's, a lot of people watch the trial. I now know that your attorneys recognize their own handwriting. That's very concerning to the court because very few people would have had access to that. And I have to be concerned with the integrity of these proceedings as well. I read the cases that the that the defense cited, and in particular, State versus Miller. There's a difference when ineffective assistance of counsel and a conflict of interest is raised in a post-conviction proceeding, and what a defendant or an attorney, or even in the Miller case, there's a discussion of when the state raises a concern with counsel. And that in that circumstance, which is really not what we're dealing with here, that it can't just be fabricated to get, counsel off of a case when there's an adversary that, the state might think is formidable. That's what it's talked about in that case. But this is raised prior to sentencing.
I agree, Eva Queen.
And I believe the case law is pretty darn clear that if I can find there's an actual conflict of interest or a serious potential conflict of interest, then I have to presume there's prejudice. That means I create a situation, if I make all those findings, that cast doubt on the entire sentencing hearing if I force attorneys Kukler and Galavis to stay on. That's what we're dealing with right here. And for everyone, the court now, I'm right here with everyone. Is it frustrating? Absolutely. Do I want to get this case concluded? Absolutely. Do I want to give Ms. Kurczewski the opportunity to file her appeal, which presumably will follow and raise issues? Absolutely. I'm well aware there's rulings you will absolutely want to appeal that I made. One of which is the jury instructions. I get that. And for the victim, there needs to be finality as well, but it does no one any good if I ignore all of this, simply plow forward and then have to redo it at a later point in time. I'm a big believer, right? Let's do things right the first time to avoid that appeal, or at least that particular issue. And I think there's an argument that if I ignore all of this and later on a court of appeals or Supreme Court says this was an actual conflict of interest, or one at least that rises to the level of being a serious potential conflict of interest, then that would likely be the remedy, assuming all other issues, would be affirmed. So I'm mindful of that as well. This weighs heavily on me. I've spent a lot of time looking at it. I've looked at the various ethical provisions. And while I agree with the state that it can't be just an allegation from a disgruntled or desperate defendant, generally speaking, there has to be something more. It is important, Ms. Kurczewski, that I know your position on all of this as well, because also in the case law, there's a recognition that even with an appointed attorney, if this is who you want to continue representation, that matters as well. And I don't know your position, so I'll ask you. I don't want you to comment on anything else. Merely, do you want either Attorney Galaviz or Attorney Kugler to represent you at sentencing?
I did. I do not, because up until yesterday, neither one has done anything for me now because they had halted all proceedings due to the DA conversation they have had. So at this point, as much as I wanted to get out of Waukesha County and proceed forward and go through appeals, I don't, because nothing has been done for sentencing except last minute yesterday. Partial. I have letters of character in limbo. I have nothing completed for sentencing. So no, I don't. And I frankly blame the state for that. They proceeded to release this information, which should have not been done. And it has created this mess. So while they are requesting they should not withdraw on their behalf, I don't think this is right. Everything has been done wrong since they have came forward last week with this information. And I do say, no, I did not write it. There's cameras all over this jail. There's recorded phone calls. There's a lot of issues here that no, everything should be stopped. And I need to look at my legal rights because I don't know what they are at this point.
I can
Moving
tell
forward, no, I do not think because of everything that I have since learned, no, I should not have either attorney, which is very hard, proceed at this point, and sentencing should be stopped today.
I can advise you that even if I require them to stay on, I would not go forward with sentencing today because I'm mindful that there has been a pause. And so knowing that if I were to keep them on, I would adjourn sentencing to give them time to prepare. Does that change your position in any way?
No, I don't think either one of them feel comfortable staying on, so I would prefer not to at this point because of the conversation or little of conversation I've had with both of them. I would prefer not to, no.
Do you understand that could be a significant delay?
Unfortunately, yes, I do. And that is more upsetting, and that is on the state at this point. They released this information. They made this mess. It should have been stopped, but they did this. And that is quite frankly very frustrating. And they have nobody to blame but themselves right now. And it is very frustrating. It is very frustrating. And I was told walking out of the detective's office last week, just so you know, you probably will not be leaving anytime soon because of this, knowing I wanted to leave. I have not told them I did not write these letters. So again, that is coming from what? My phone calls? My conversations?
All right,
I did not.
We should,
I'm
I'm going to advise you at this point that I've heard your position. You should consult with an attorney
I would love to. I still have two on
before
record and nobody will
making any
talk to
further
me.
statements.
I've been trying all week. And I
So-
have tried, I have a letter for you that I have tried to get through the jail, but I will not send it anywhere because I don't trust putting anything out there. So I have had a letter since Sunday for you. I couldn't send it. I have it with me today.
Well,
Obviously, I
I'll
don't
accept
tear
that
you down.
filing today if you would like to provide it. And it will be uploaded and e-filed and it will be part of the record.
That is completely fine.
Attorney Sitzberger, I want to turn back to you because the state has made this request that I consider this 37-page document, presumably because you believe it is relevant to sentencing, I guess, on the character of Ms. Kurczewski. Would I be wrong in that assumption?
No, Your Honor, and I would say that we didn't release anything. We filed appropriate documents with the court when they came to our attention that directly go in our position to Ms. Kurczewski's character. And we are duty bound to inform the court of everything that's relevant to sentencing, which, as this court knows, character is at least 1/3 of the equation. So we filed those. We tried to give the defense attorneys ample leeway in seeing those and offered them to see the originals before we filed them with the court. That's
But you
all
made
we've done.
some, I would say, assumptions in your letter that these are written by Ms. Kurczewski and, you know, some of the facts and circumstances surrounding that. I mean, from my perspective, there's an allegation that she is the author of the documents and that somehow they made its way to a person with whom she has some connection. I mean, at this point, I mean, it's not like I can simply undo the filing. I know I referenced that earlier and, you know, does that solve the issue? Does that remedy if I simply say, I'm not going to consider it? I don't think it does that given the nature of the filing. But the flip side to that is, why wouldn't the state want more information about it so that at the time of sentencing, if I allow it, it's more accurate? Why wouldn't I want your investigation to conclude?
In a perfect world, we'd all want that, Judge, but we're trying to balance a lot of interests here, as the court is. We know that everybody involved in this case, the defense included, has been going through this case for 5 years now. The court case itself, probably 2. The trial was long. So there is an interest in finality, obviously, especially to the victims and the victims' loved ones. We file things and we may never know the answer to some of these things. Now, perhaps time will reveal some more answers, but I can say with certainty that the detectives have been looking into this, I would say on a daily basis, trying to figure out that gap in time. How did they, right, and it's our position. The letter I filed was to put forth the state's position on these things, knowing that the defense would have an opportunity, and that's why we asked them to look at the originals ahead of time so that they could be prepared to file their position with the court. I think that's what the state does in a great many filings. In criminal complaints, for example, we put forth what we believe the evidence shows. Of course, there are allegations, and I can't prove this beyond a reasonable doubt at this point that Ms. Kurczewski wrote. I can say that it came to our attention. We wanted to give the court ample time to review these documents. We were not just going to assume that at the time we filed these, sentencing would be adjourned automatically. So we've given the court a week with these documents from our filing date. And the detectives have been working hard to answer all of those questions the court has, and frankly, the state has, and I'm sure the defense has. We just haven't been able to solve some of those answers, but we thought it certainly relevant that these were written on the back of trial notes, that they're dated, that they're made to look like certain pieces of evidence the state put forth as fraudulent during trial. Obviously, they're not those items because they were written on the back of trial notes. The letter purports to be from Jessie. She signs her name. I'm no handwriting expert, but the writing looked similar to what we had seen from her handwriting. And she's the only one to gain from having somebody file the things that are requested, a tape recording of Lynn Hernan admitting to being suicidal and essentially putting together a suicide tape and sent to your honor from a concerned citizen with no return address. The envelope itself, the return address portion is a person we know to be very good friends with Ms. Kurczewski. And we've, of course, redacted her name and address so it doesn't get out there inappropriately. But that's not something we believe a great many people that could have just picked up Ms. Kurczewski's trial notes would know, and even know to include as the return sender. Now, detectives have gone and talked to that individual, and she claims to know nothing about this at all. So we may be left with no answers. At this point, we don't have them, and I don't know that I don't know what percent likelihood I can put on it. I know Detective Plennis informed me today that he's had hours upon hours of jail camera footage put onto a hard drive. I believe it's taken up quite a bit of a hard drive so that it can continue to be reviewed to see if that lends any clues. But knowing that sentencing was today, it was absolutely filed so that this wasn't a last second request for the court to review 37 pages and spring it on everybody as to what the state thought this was. I thought it fair to everybody to put forth the state's position along with the documents itself, along with the opportunity to review the originals because they were double-sided and a single-sided copy. It took the prosecutor team a little time to figure out a single-sided copy on what we were looking at until Detective Plennis had time to sit down and show us the originals. So we first offered that to the defense team before filing with the court with what I would call a guide as to how to read it, given that we could not just bring over the originals to your honor ex parte and show you them.
Have you had an opportunity to discuss the motion to withdraw with the victim?
We have. Our victim witness advocate has been keeping them informed really over the past week as all these filings have come in.
Do they have, does Mr. Posa have, because of the count 3, does he have a position on this or wish to address the court in any way in compliance with victim rights?
It really sucks that all these people had to come together and now it looks like they're not going to be able to do their victim impact statements. There's not going to be a full sentencing hearing. I mean, these people wait for these days for a long time and now they have to
John, I've confirmed with
wait
Mr.
for another
Posa,
day.
who's present in the court, that he does not wish to address the court, but he's obviously very opposed to this. He's been opposed to a great many of the continuances in this trial, understanding that a lot of them are necessary, but certainly there's a great interest in finality to this case.
Of course. I'm so glad I'm not a judge.
Attorney Kukler, I'll ask this to both you and Attorney Galaviz, but I want to make clear that I understand the basis for your request is you believe that, or let me state it this way, your request is made under SCR 20:1.6 sub, that's parenthetical B. Is that, do I understand your request correctly?
Yes,
And without divulging confidential information, you have made that request because you believe there's an actual conflict of interest here.
I do. I believe that. And you know, this court knows me from many years of practice and know that I rarely, if ever, have withdrawn from a case.
Thank you. Attorney Galaviz, same question or questions to you. Your request is under SCR 20:1.16 parenthetical B.
Correct, and I mean, the state bar ethics told me to cite A as the reason, but B could also be used. It's an obvious conflict.
You have cited actually A and B. And you did, as your motion states, you did consult with the ethics individuals at the state bar.
Correct,
And they made a recommendation to you.
correct.
Attorney Kukler, did you do anything like that, or did you rely
Bless you,
upon
whoever
what
that
Attorney
was.
Galaviz had done?
That's right. I relied upon what he did.
Yeah, I just,
These types of motions are always
ugh,
difficult for the court, especially when the court has not only presided over what was a trial that lasted almost 4 weeks, um, many motion hearings, significant motions related to the experts in this case, and a case such as this where we don't really have any more significant crime than the crime of first-degree intentional homicide. And it's difficult because, like I said earlier, I don't want to set a precedent that simply leads someone to believe that you make an allegation against an attorney and that's enough to get that attorney off the case. Oftentimes, when we're in the beginning stages of litigation, there's a little bit more leniency when it comes to these types of issues. And this is, I can't say unique, but the circumstances here are important to note that there has been a trial and a significant trial and significant litigation for a very serious crime, and in fact, more than one crime for which Ms. Kurczewski has now been convicted. And lawyers, all lawyers have, in addition to their obligations, for example, for a defense attorney to their client, but all lawyers have the responsibility to be truthful with the tribunal, to have candor. And then, of course, there's all of these confidentiality requirements that apply to Attorney Kukler and Attorney Galaviz. And there's very, very limited circumstances that a lawyer is obligated to reveal information and then even permissively required to reveal information. And I mentioned this earlier and I took a look at that. And I honestly think when you look at it, it's really a stretch. I know I mentioned it, kind of to ask a probing question. It's kind of a stretch, though, to say that there's any requirement or even permissively that allows attorneys Kukler and Galaviz to reveal information. They're officers of the court. They believe that they have an actual conflict of interest, and they've asked to withdraw. I know from my review of the Supreme Court rules that part of the ethical considerations aren't only to maintain that confidentiality, but obviously lawyers may not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. But a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. And so, I'm mindful of that. I'm mindful of the rule that's been cited, which is why I asked for confirmation from the lawyers. SCR 20:1.16, terminating representation, sub A states that, except as stated in paragraph sub C, a lawyer shall not represent a client, or where representation has commenced, shall withdraw from the representation of a client if the representation will result in a violation of the rules of professional conduct or other law. Sub B, again, except as stated in paragraph C, a lawyer may withdraw from representing a client if the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. The client has used the lawyer's services to perpetuate a crime or fraud. Or 4, the client insists, sub 4, even though it's not the fourth one I've read, the client insists upon taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement. I'm also mindful of what this filing actually contains. And when I reviewed it, it's not just a single reference to the attorneys, but on page two of what I would call kind of the cover letter to this document. States as follows: even this envelope didn't go out through jail mail. My attorney took it. This was one of my attorney's ideas, and clearly they aren't going to tell anyone. On the second page, which is the third page of that cover letter, but the next page after that, it says, we are trying to make a stir, a big stir, to show just how wrong they are. Again, very general. And those are the references, I guess, to counsel. This filing clearly raises a concern for the court because whomever wrote it, and I think I do need to consider for purposes of this hearing that one possibility is Ms. Kurczewski is requesting another person to engage in fraudulent and likely criminal activity related to the fabrication of evidence. It's been provided by the state as a request that I consider it at the time of sentencing under my authority and the criteria that I am obligated to consider, right? The three primary sentencing consideration, the galleon factors, one of which is the character of the defendant. That's why the state has presented this information. This information, though, it presents many more questions at times than answers, some of which we've already discussed, including the fact that there is no postmark over the postage. There is what appears to be a stamp from the Waukesha County Jail. I'm now told, and I didn't, I guess, catch this during my review, is that envelope has a crease in it, whereas in all the other documents within it do not. There is information within that filing, as has been explained here today, where there's a verification that they are contemporaneous notes. Attorney Kukler indicated she recognized either her own or Attorney Galavi's handwriting on it. So there's some legitimacy to as to how or when, I should say, that was part of this exhibit or this document was created, right, contemporaneously with the trial or during the trial. When I consider all of that, I think I am left with the inescapable and unenviable decision here today to make a finding that at a minimum, there's a serious potential conflict of interest, perhaps even an actual conflict of interest. Looking at the authority in State versus Miller, this court must presume prejudice to Ms. Kurczewski in requiring her attorneys to represent her going further. She does not have an objection. I think there's an additional basis that there has now been a serious breakdown of communication and a difference of objectives between Ms. Kurczewski and her counsel, that this is a relationship that cannot be mended. Even though it means that this sentencing hearing must be adjourned and that new counsel be provided for Ms. Kurczewski, I am going to grant with reluctance, but I think it's the right thing to do, the motions to withdraw by attorneys Kukler and Galaviz. Rather than reset a sentencing hearing today, knowing that this was a very lengthy trial for which transcripts may very well need to be obtained, and or new counsel review the live stream recordings that are available online of the trial itself. Certainly talk with Ms. Kurczewski, maybe even talk with attorneys Kukler and Galaviz at a minimum, get all discovery information from them. And last but not least, to give the state an opportunity to fully investigate this issue and present more accurate information to the court at the time of sentencing. I do believe it relates to a legitimate sentencing consideration, but as it states right now, this filing, I think, presents some more questions than answers, and I think more time also gives the state an opportunity. I have to be mindful that both sides have the right to a fair hearing at sentencing. And it would likewise be unfair, I think, to the state if I simply said this isn't coming in as well. I will let them argue it, present it, and any additional information on it at the time of sentencing. New counsel can certainly object, and it, of course, will be up to the court at the time of sentencing to put whatever weight, if any, on that as I consider which or how to impose sentence on Ms. Kurczewski for all of these offenses. Given that it is early December and we have some holidays coming up, given that it may take some time for the public defender's office to appoint, because she does qualify and will continue to qualify, I will set this over to early January for status of counsel. I believe, Attorney Kukler, you filed a proposed order. Attorney Galavis, did you file one as well?
Yes, Judge.
All right, then those both should be on my dashboard. I'll look for those. I'll sign them. And that will then trigger the public defender's office. Attorneys Kukler and Galavis, what I ask is that you cooperate with whomever is appointed and work with them at getting all discovery to them, and all information and notes that you have from trial to that attorney or attorneys, if that's the case, and do that as promptly and efficiently as possible so that there can be the fewest delays going forward.
Yes, Judge.
For purposes of the next hearing, although I'm allowing you to withdraw, if discovery has not been turned over to successor counsel, I'm requiring both of you to come to that next hearing with discovery that you have, just in the event it didn't take place. It's my way of enforcing that.
We will send ours electronically to whoever is appointed.
Even including trial notes and things of that nature that you would give to successor counsel.
We have everything ready electronically for
Okay, very well.
counsel.
Then I'll take your word as an officer of the court that that will be done, and that can probably be done very quickly then. But again, if it for some reason hasn't happened, then one of you at least should be here.
That's such a miscarriage of justice for the families. It's so sad. It's a 37
Would
page
everyone be
letter.
available on Friday, January 12th at 10:30 a.m.?
That works for the state. Oh, I'm sorry.
Okay with me?
Yes, that's good.
All right, that will be for status of counsel and for further scheduling. And again, I'll, as soon as we're done here, look at those orders. I'll let you know if there's an issue with them, but presumably I'll sign them and we'll go from there. Thank you, everyone. That does conclude the hearing.
Thank you.
And we'll be in 10:16.
Well, there you have it, everyone. The motion was granted. I was looking for the letter itself, and it is 37 pages. So a little long to read, but I encourage anybody who's interested in this case to look for that letter. It's a doozy. She basically tells somebody named Jessica that her and her attorneys have come up with this great idea to forge documents and prove that the victim actually committed suicide, and somehow it got into the state's hands, and the state, submitted it. I started this channel after, or revamped this channel after this trial happened, or I would have carried it, because it was a crazy trial. And as I said, I like this judge, even though she's a little bit long-winded in her sentencing and things like that. I like this judge. She's the same judge that presided over the Dorow Brooks case, and Dorow Brooks was much more problematic than Jesse Kurczewski, but Jesse Kurczewski is also very problematic. She's definitely a handful to deal with. So yeah, more miscarriage of justice for a family, more fuckery, basically. It looks to be from this defendant, who continues to declare her innocence, and continues to declare that she could never. Whoa, 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 whoa. Where is that coming from? Wait, sorry, hold on. Don't you hate it when a tab starts playing right in the middle of when you're talking? Anyway, all right. Thank you for being here. Please remember to hit the thumbs up, and I will see you in the next stream.